Welcome to the fourth of the current criminal evening sessions. I'd like to introduce, if I could, tonight's panel for you. Seated in the middle is your moderator for this evening, Marlys Edward. Marlys was called to the bar in 1976. She is a practicing member of the Criminal Defense Bar, and her practice, as I understand it, is restricted to criminal law, and she, of course, is a partner with Clay Ruby. She belongs to the Canadian Bar Association, Criminal Lawyers Association, and all other standard organizations. On my far left is Lou Silver. Lou graduated from Osgoode in 1962, called to the bar in 64, became a QC in 1975. His practice has been restricted to criminal law since the time of his call. He's a member of the Criminal Lawyers Association, the American Association of Criminal Defense Counsel, member of the County of York Law Association. He has taught at various times at Osgoode in the bar admission course. And sitting next to Lou is His Honor Judge Wallace. Judge Wallace was born in Buffalo, raised in Fort Erie, graduated from McMaster in 1953 in an honors history and economics course. He graduated from Osgoode in 1957 and then practiced law in the Welland, Niagara Falls area for some 18 years. He was appointed as a provincial court judge on January the 1st, 1976, and at one time was a former alderman, city council in Niagara Falls. On Marlys's immediate right is Sergeant Bob Strathdee. Unfortunately, Sergeant William Liga could not be with us tonight, but we're most grateful to Bob for filling in on his behalf. Bob joined the police force as a constable in March of 1962 and went to work at 22 Division in uniform. In 1967, he moved into plain clothes and worked in drugs, prostitution, and gambling at 22 Division. He then moved to 52 Division in 1970 and was in plain clothes and worked in drugs and vice there. He was promoted in 1974 to the rank of sergeant and worked at a 52 Division in the General Criminal Investigation area. In March of 75, he went to head up the 1st Downtown Drug Squad. He left in March of 76 and went to the Intelligence Department and worked in the areas of counterfeit money, drugs, gambling, but primarily extortion and loan sharking. In June of 1980, he started full-time in the gambling section of the Intelligence Department. Our last member of the panel, who is presently waiting for a jury and may have to be called out, I imagine, at any time, is Peter DeJulio. Peter graduated from the University of Toronto with a Bachelor of Arts degree in 1969. 1972, graduated from Osgoode Hall Law School, and in 1974 was admitted to the Bar of Ontario. In 1974 to 1976, Peter was associated with the law firm of Montgomery Castles in Toronto in the practice of civil and criminal litigation. And from 1976 to the present, Peter is an assistant crown attorney for the Judicial District of York and has specialized in prosecutions involving morality-related offense. He's done numerous gambling, gaming house cases, prostitution-related offenses, obscenity-related offenses, and he is truly an expert in the field. Ladies and gentlemen, your panel for this evening.
Thank you very much, Michael. I think we've all agreed that we're going to start this panel off with a general discussion about bookmaking. And in order to do that, it was our assumption that it would be useful to have Sergeant Strathdee define and outline what the basic structure of a bookmaking organization is and some of the terms that are most frequently used to describe the different actors in the organization. Sergeant Strathdee?
Ladies and gentlemen, as a way of introduction, I would like to advise you of a CFRB newscast that I heard last night in relation to Frank Dray's proposal about off-track betting and credit betting, for lack of a better word. Toronto was described as the third largest illegal gambling city in North America. And to be completely frank with you, I just caught the tail end of it, and I don't know what the first two cities were. I think we can safely assume New York would be one. That's enlightening in itself. Toronto is by far the leader in illegal gambling with bookmakers in Canada. It's a multi-million-dollar business. It involves bets on most sporting events, specifically Canadian football, Canadian hockey, all the professional baseball games, both in and out of Canada and the U.S. It involves basketball in the United States and horse racing both in Canada and the United States. All these events, bookmakers in Toronto will accept bets on these events. The value of having a bookmaker to a bettor. Any of you here that play the horses presently, legally, you have to get in your car and drive to Woodbine or Greenwood and place your bet. The bookmaker takes all that inconvenience away. Your bet can be made with one phone call. Bettors fancy themselves as experts in the various events, specifically away from horse racing. Bettors will call Los Angeles, California to check on when the grass was last cut on the football field. When did it last rain? What's the wind expected to be at 2 o'clock in the afternoon? These bettors that I'm referring to, these are people that are betting anywhere from $1,000 to $10,000 on that particular game with one phone call to a Toronto bookmaker. I think any one of you here, a group of 10 of your personal friends, one of them will know a bookmaker. And if they don't, they will know someone that can lead you to a bookmaker. People that bet are of every profession you can think of. Doctors, lawyers, police officers. And I'm talking about the illegal gambling with the bookmaker. To explain the bookmaking operation, the bettor will contact someone who we refer to as a sheet writer. A sheet writer is a fellow who records your bet. You have his phone number, or he has your phone number, and you will communicate, and you will say, Toronto Maple Leafs $100, and he will write that down beside your name. And his phone, the sheet writer, is continually busy. That's all he does is just record the bets. He will deal with a man who we refer to as the back end. Now, the back end man, his responsibility, he has many of them actually, but one of them is to continually check with his sheet writers. He doesn't necessarily have one. He could have 6 people that are just taking the bets on his behalf. And what the back end man is concerned with is the amount of money that's being bet on any particular event and which way the money is going. By that, to use last night's hockey game, Montreal-Toronto, for example, the back end is concerned as to a situation where $90,000 may have been bet on the Leafs and $5,000 on Montreal. He's got a great discrepancy there. And if the game goes the wrong way, the bookmaker, back end, the whole operation stands to lose $80,000. By way of explanation, every bet that is made with a bookmaker, to use the $100 example, a particular $100 bet, if you're successful, you'll be paid $100. If your bet loses, you will owe the bookmaker $110, 10% of the bet. Whatever the bet is, 10% of that is added on to the figure that you lose. That is referred to as juice. A well-run, organized bookmaker operation will have a back end And his aim, using last night's hockey game for example, his aim is that when all the bets are in, he has an equal amount bet on each team. The bookmaker then can put on his hat and coat, go out and have dinner, could care less who wins the game, but be assured of 10% of the losing bets. That's what they strive for. That is what an efficient operation is. More often than not, you don't have an efficient operation. You have a bookmaker that will, as we say, play the better, and he won't lay off, and invariably they get in trouble. Every bet, 10% of it, of a losing bet, is added on to the figure that has been bet. That's where a bookmaker makes his money, or attempts to. The back end person that I referred to, he invariably, to avoid detection, will call the sheet writers. The sheet writer won't be calling the back end, because if the sheet writer was stopped or investigated by the police, the phone number was obtained, it would necessitate the back end man setting up in a new location. The way he gets around that problem is he makes the calls to the sheet writers. The back end person will also keep on top with his sheet writers. He'll keep on top of the figures of all the bettors, and by that, John today, as a result of last night's bets, is minus $600, and Pete is plus $50, and Joe is minus $1,100. The back end man keeps himself apprised of that information every day. The back end man will dictate limits on various bettors. And by that, I mean he'll tell the sheet writer that Joe has a maximum bet of $1,000. Do not accept bets in excess of that from Joe. That's the back end man's responsibility. Again, balancing the books, the back end man. By that I mean laying off. And by way of explaining that, using the $90,000 versus $5,000, Toronto and Montreal last night. In Montreal last night, in the bookmaking trade, Montreal there might have been $90,000 bet on Montreal and $5,000 on Leafs. So when you put Montreal and Toronto together, in my example, you have an equal amount bet on either team if you combine the two. So the bookmaker in Toronto will know the bookmaker in Montreal, and they'll saw it off in the middle, and they will have achieved what they want to achieve. And both in Montreal and Toronto, they will collect 10% of the losing bets. And if you figure on one game using an $80,000 figure, half of those bets, when the back ends are finished balancing between Montreal and Toronto, that's $40,000. 10% of that is $4,000 on one game. I think there were 5 or 6 games last night. Tonight, there are hockey games and there's an NFL football game. The same things will happen. Bettors get themselves in problems with the bookmakers when they overextend themselves. They get themselves in positions where they make promises for 2 or 3 weeks that they will pay the man who collects the money, and they don't. Now you come into the problem of the bookmaker or back end having to take other steps to collect his money. The bookmaker cannot let a bettor beat him and not pay him, because if he does, that word spreads, and the rest of the bettors that are delinquent to the bookmaker, they see that the one fellow that balked at paying, nothing happened to him. So something has to happen to that one bookmaker. A variety of things happen, threats. The ultimate is when the bookmaker will sell the bettor's debt for 50% of its value to a loan shark to collect. That's taking it to the extreme. Your moderator has asked me to mention terms that are used. in bookmaking. The horse bets involve basically the bets that you can make at the track. Win, place, and show, exactors, reverse exactors, which means you bet horses to finish 1-2, and if they finish 2-1, by making it a reverse exactor, you collect. Daily doubles, wheeling horses in the daily double, where they'll bet one horse in the first race with everything in the second. Bookmakers accept all these bets. In football, which presently is the major betting activity, specifically National Football League games, the amounts of money are referred to that are bet as 1/2. 1/2 is $50. 1 is $100. A nickel is $500, and a dime is $1,000. Those are the types of bets that are made on football. Parlay bets are also made on football, where a bettor will pick 2, 3, 4, 5, as many teams as he wants in what they call a parlay bet. Basically, what he's bet, he might wager $200, and he could stand to win $2,000, but all the teams have to win. One loses, he loses his total bet. In football bets, there are round-robin bets, which basically it's a reasonably low outlay, but it pays off handsomely. Basically explain it as picking 4 teams, and they have to intercombine, and all must win by a certain point spread as dictated by the bookmaker. That bet is also referred to as a twister. In hockey bets, you have a puck spread and you have a money line. To pick 3 lines last night, Toronto was a half 6-7 over Montreal. Basically what that means, Toronto was a half a puck favorite, and if you wanted to bet Toronto, you had to bet $7 for every 6 you'd receive. Philadelphia was playing last night. They were 1, 1, and 1.5. These are the phrases that are used. You have a game where you have no points or a puck spread, it's referred to as a pick'em. Pick'em a half 1. Basketball, National Basketball Association of the United States, it's strictly done on a point spread, a differential between 2 teams. A team is 6 points better than B. That means A must beat B by more than 6 points for you to collect your bet. They also have an over and under bet in that game, and that basically means in basketball the scores are roughly around 100 for each team. They might pick set a line of over and under 220. Takes in the combined score, the eventual outcome of the game. Does it total more or less than 220? Bettors will bet over or under. Each number, the over and under number is changed for each game. In relation to Toronto and statistics and betting houses, specifically bookmaking charges laid in Toronto, in 1977, there were 966 of those charges laid. In 1978, there were 670 of those charges laid. 1979, I'm afraid I don't have the figures. In 1980, this year, until the last month, there were 437 laid.
Sergeant Strathdee, just a couple questions. Do you have any idea, or is there a rough estimate of the number of individuals who would belong to any bookmaking organization and what their average take might be in a week?
Well, that would depend on the number of sheet writers. It would depend on the sophistication of the operation. The higher up in the organization one would go, the more insulated from detection those people at the top would become. There are sophisticated operations in this city. As I said before, the sheet writer is the fellow that accepts the bet. And the particular operation may have 1 sheet writer and they may have 10.
So there's no standard number or commonly found number of individuals?
No.
With respect to the organization that you've described, Have the methods of detection or police investigation changed over the course of years? And perhaps I'll address that to Peter for a moment.
Yes, I think they have. Am I coming in clear?
Quiet.
All right, is that better?
Yeah.
There's much greater emphasis now on wiretap evidence. Crowns couldn't prove their cases without it in many situations. For that reason, I stress that it's very important for both Crowns and defense counsel alike to be extremely conversant in wiretap evidence. Very frequently, once a wiretap transcript has been ruled inadmissible, the Crown's case goes out the window and it's just closed at that point. It's particularly useful in charges such as keep a common betting house and charges such as record and register bets, where much of the offense consists of transactions over the telephone. In those cases, in addition to the wiretap evidence, of course, it's usually necessary to call someone like Sergeant Strathdee to give evidence as to the betting jargon and what it means, because the court can't take judicial notice of that sort of thing. It's not so useful in other types of betting charges, such as keep a common gaming house, because the essence of the offense there is operating a place used for the playing of games. Most of the cases that I see, and probably most of you people will see, involve a bunch of, it usually ends up being a bunch of Italians for some reason at a local pool hall or something, who are playing cards and gambling, and the owner is making money either from the snack bar or taking a cut from the games. In that sort of situation, wiretap evidence isn't as crucial, because the case depends more on physical observations. Where wiretap evidence isn't useful, for example, a gaming house case or a betting house case, one thing that is useful, if you can do it, is use one of the found-ins to testify. That's very helpful, because he can give evidence that the place is resorted to for the purpose of playing games, and he can also give evidence about the knowledge that the alleged keeper has or may have about what's going on the premises. Frequently, however, found-ins are very reluctant to testify against the keeper. Often they're friends, and you usually have to end up making some concessions towards the found-in to get him to testify. The usual one is that you promise to withdraw a charge against him afterwards, or you promise not to ask for a jail sentence if he's convicted. That often induces him to testify, but the difficulty, of course, is that defense counsel generally aren't naive, and they realize these things are happening, and they put that to the witness on the stand, and it certainly impugns his credibility.
If I can just stop you there for a moment, do you find that a lot of defense counsel who represent found-ins are coming in with that kind of offer in order to get their clients off?
I find it happening more frequently these days, but I'm still a little chary about accepting those offers because of that.
Okay.
One of the things I try to do if we do charge found-ins is usually found-ins are inclined to plead guilty, and a useful technique that's not used as often as I think it should be is for the Crown, if he's reading in the facts to support the guilty plea on the found-in, rather than merely read that the found-in was in such and such a place and there was gambling going on, read into the record the name of the keeper and the exact address of the premises and the times, and have the found-in either state under oath, or at least on the record, that he agrees with those facts himself rather than his counsel, and order a transcript of that. And then when you do call the found-in at the trial, whether he's a willing witness or not, you can put him on the stand. If he doesn't want to give the evidence, you can get him declared a hostile witness and cross-examine him on that transcript that he's already admitted to. Now, some people may think that's a little dirty, but I think it's fair play.
Well, Marlys, if I may interject for a moment, I'm just wondering why Peter has never given consideration to the use of Section 183, which permits the Crown to take a found-in, indeed anybody found in premises that are used for a disorderly purpose, and require them absolutely to give evidence under oath, which evidence specifically cannot be used against them, but may be used in the proceedings as a whole. It seems to me that this particular provision has not been used in this jurisdiction in my memory. I don't know of it ever being used in Ontario at all, for that matter, and I'm just wondering if there's a policy decision here or some other reason why it isn't used.
Peter, do you want to address that?
All right, I don't think I can give you an answer to that. I've never seen it used. I sense that there's some reluctance on the part of the police department and in the Crown's office to use that because it may be a little heavy-handed.
Was it any heavier-handed than forcing a found-in to give evidence and ordering a transcript? I mean, that seems to be doing by the back door what you're entitled to do by the front.
No, I find my method more palatable, but maybe I'll consider yours as well. Two are better than one, I suppose.
I find it rather strange that your found-in cases would be coming before the court in any event prior to a determination on the principal case of common betting house or common gaming house, as the case may be. In my experience, the found-in cases normally abide the result of the substantive case, and only when the premises has been determined to be a common gaming house or a common betting house, as the case may be, are the found-in cases dealt with. And I would find it unusual for a found-in to be volunteering to plead guilty before the premises itself had been found to be a disorderly house.
Is there a policy in this judicial district with respect to proceeding with one first and then the other?
Well, as a matter of practice, we normally proceed against the alleged keepers first, but we do run into cases where a found-in wants to get the matter over with because he doesn't want to retain an agent or keep coming back to court himself, and he senses that he'll probably only get a very light fine and would rather just get the damn thing over with and is willing to plead guilty on the first occasion.
And there's no policy in the Crown Attorney's office to not accept that plea?
None that I'm aware of.
There
might be some reluctance on the part of the bench in certain areas to accept such a plea if the judge were advised that the principal case had not yet been dealt with.
In your jurisdiction, has there been a tendency to refuse to accept pleas in those circumstances?
There has.
Remind me not to take my cases to your
And
jurisdiction.
is that often a result of a request put forward by perhaps defense counsel asking?
If the request is made, the request is granted. If the request is not made, the court would exercise its discretion and act on its own behalf, notwithstanding the absence of a request.
And that would be inquiry from the bench to the Crown Attorney as well?
Yes, the bench would inquire as to whether or not the main case of common betting house, bawdy house, gaming house had been dealt with. And if the court were advised that that case was still pending, the found-in charges would be adjourned pending the outcome of that case.
Mr. Ungaro, are you paying attention?
No comment. Let me ask His Honor to turn his mind for a moment to the role of presumptions mostly presumptions that occur in this area of law. Have you found in your court prosecutors relying on the presumptions as they're set out in the code to establish their case, or are they using other kinds of evidence? Do you want to comment on that and some of the nature of the presumptions?
Well, I suppose any good prosecutor uses whatever he has. If he has a presumption or two going for him, obviously he attempts to take advantage of them. And conversely, defense counsel are attempting to elicit facts to establish a situation where A, the presumption would not arise, or B, if it did arise, the facts would neutralize it or negative it. I don't know of another area of the criminal law where the path is more heavily strewn with presumptions. There is a special section, of course, in the criminal code, section 180, which sets out in total some 5 presumptions that apply in disorderly house cases. For example, if the peace officers are willfully obstructed or delayed in entering a premises, then in the absence of any evidence to the contrary, that fact is proof that the place is a disorderly house. Another example, if a place is found to be equipped with gaming equipment or any device for concealing, removing, or destroying gaming equipment, and examples of that might be flash paper, etc., then in the absence of evidence to the contrary, proof that the place is a common gaming house or a common that is proof that the place is a common gaming house or a common betting house, as the case may be, and so on. There are also other presumptions apart from Section 180. For example, there is a presumption that I understand we'll be dealing with later, there is one presumption in Section 193, subsection 4 of the Criminal Code, which says that in certain cases, if a landlord has been given a notice that a premises owned by him has been found to be a common body house, that the landlord is required to take steps to see that there is no more recurrence of the problem, and if possible to terminate the tenancy. And if the problem continues in the absence of evidence to the contrary, the landlord can thereafter be charged and held to be the keeper of a common body house. There is also a presumption in the code involving persons living with prostitutes who are, in the absence of evidence to the contrary, deemed to be living off the avails of prostitution. In fact, this whole area of the criminal code is so technical that I would suggest that a greater amount of care and time is required in the preparation of a defense for one of these charges than would be required for a defense in a less complex area of the criminal code, for example, a defense on a theft count or a defense on an assault count. Indeed, I'd go one step further and say this, that this particular area of the criminal code being so complex and being filled not only with many presumptions but also with many complex definitions, that this is not the place for an inexperienced neophyte counsel to get his feet wet in the criminal court system. And I would go on to say that if an inexperienced counsel were retained to defend a case in this area of the criminal code, that where the retainer permitted, that counsel would be well advised to seek either another more experienced counsel to act as co-counsel with him or senior counsel with him at the trial, or in the alternative to obtain advice and assistance in the preparation of a defense from that senior counsel prior to proceeding with the trial of the matter.
If I may, Your Honor, can you be a little more precise and outline what areas in particular you think junior counsel have failed to give an adequate performance in your court?
Well, I don't want to go into specifics, nor do I wish to name any particular counsel by name. In general, let me say that I have had instances in my court where, at the conclusion of the Crown's case, there was a situation where either A, the Crown had failed to prove a prima facie case, or B, there was some doubt at the conclusion of the Crown's case as to the guilt of the accused. I have then had counsel come before me and call defense evidence, whereupon at the conclusion of all of the evidence in the case, there no longer was any doubt, and the charge then had been proven on all of the evidence against the accused beyond a reasonable doubt.
Let me ask you, Lou, in your experience in defending these kinds of cases, is the major difficulty coping with the presumptions?
Well, presumptions are always a difficulty because they make the hurdle a little higher, so to speak. But I think we have to realize that presumptions are, in a sense, only a tool for the Crown. What they do, in effect, is neutralize the presumption of innocence as we know it. They don't do away with it, they neutralize it. But the onus remains on the Crown, and the Crown still has to prove its case beyond a reasonable doubt. Let us say, for example, that with the presumption applying, the defense is able to raise a reasonable doubt on one issue or another. That would be apropos His Honor's remarks, because then I would be minded to go with that reasonable doubt raised on the Crown's case, as distinguished from filling in all the holes the Crown has failed to fill in by trying to refute the presumption in a categoric manner. Now, let's look at some examples of that sort of thing. Let us say the police come and the door is locked, right? And you're able to elicit from the police officers that that's all it was. The door was locked. Well, that doesn't come into the realm of willful obstruction. And if that is all the Crown has, they have not made out their case, because there has to be some willful obstruction. Another step along the line, in order for there to be a willful obstruction, clearly the individual willfully obstructing has to know that it's the police and that they are there for that particular purpose. Otherwise, he has no mens rea. And notwithstanding the presumption, indeed the presumption is put there in order to obviate the necessity of further proof of mens rea. If they can't get beyond that stage, of course, they haven't gotten very far. For example, again, being picayune and nitpicking about it, let's say they have neglected to prove an essential such as the man being a peace officer. If they haven't done that, you just go with what you've got, and I think, at least in His Honor's court, from what I've heard so far, you're going to get the acquittal. The next word is authorized to enter. Well, there has to be some authority for entering. Now, there's some old cases that say the evidence can be gathered even if the police were there without benefit of search warrant, if the police were there without benefit of any cause of entry on a prior occasion. I think in light of the recent decisions, and I think if we look at the comment in another context of Mr. Justice Euband and the Queen and Das, police officers now do that sort of thing at their peril. The trespass puts them in some danger, so to speak. And I don't think, given the wording of the presumption sections today, that evidence gathered at a previous occasion would suffice to make it out. Now, the use of the word willfully, it seems to me, makes it clear that there has to be some evidence of knowledge at the material time that the person so obstructed was a peace officer. The essence of the section. That's not as easily proven as it may sound just by reading it. And I think if defense counsel keep their eye on that, they may just find that it would suffice for their purposes simply to defend on the elements of doubt that they have raised on the Crown's case. The other thing I throw out for no other reason other than I first became aware of it today and having a look at the sections. It's interesting that section 184 creates an offense which reads as follows. Everyone who, for the purpose of preventing, obstructing, or delaying a peace officer who is executing a warrant issued under this part in respect of a disorderly house, or who is otherwise authorized to enter a disorderly house, does anything, or being the keeper of the disorderly house permits anything to be done to give effect to that purpose, is guilty of an offense punishable on summary conviction. Now, I frankly fail to see the distinction between the elements of 184 and the presumptive section, the presumptive content of section 180 in respect to those things in terms of what the Crown has to establish. And I found it rather interesting in considering the matter today to contemplate perhaps in the future, if somebody were foolhardy enough to retain me, of commencing a proceeding based on the fact that we may be into a sort of pineapple situation here. And if you could get the Crown to proceed on the 184, would that not put an end to the 180 situation, which of course is elective at the option of the Crown, either by indictment or by summary conviction, whereas 184 is strictly summary conviction. I just throw it out for what it's worth, and I leave it to such minds as Brian Greenspan's to figure out the finer ramifications.
Peter, would you like to comment on that?
Well, I agree generally that, in my view, a big mistake that a lot of defense counsel make calling their client as a witness. I think many of them would be safer to argue the case on the basis of reasonable doubt at the end of the Crown's case and elect not to call evidence. very, very frequently the clients end up convicting themselves with some help from their counsel. And I don't mean that in a deprecating sense. It's just that clients are perhaps inclined to be more honest than they ought to be on the stand, and they say something which indicates they had the proper knowledge, and the defense case goes out the window. So I agree that in more cases, defense counsel should be a little circumspect about whether or not to call any evidence at all. I don't find generally that proving a premise is a disorderly house is the biggest problem from the Crown's point of view, but rather proving either the knowledge on the part of the alleged keeper or control on his part are more serious problems. And that's where I think the Crown more often falls down.
Are there any other areas of weakness you think that the Crowns usually have to face in preparing a case like this, or under these sections?
He doesn't want to give away the secrets.
That's right.
Just a few secrets.
Frequently, the police gather evidence of a documentary nature to prove ownership of the premises or control of the premises by a certain party. And I've heard and seen cases where because of lack of preparation or knowledge with the appropriate sections of the Evidence Act, that evidence wasn't used properly by the Crown and not considered by the court because notice wasn't served or there weren't certified copies of various items or leases or whatever. So I think that's an area of weakness for a lot of, I shouldn't say a lot of Crowns, but an unsuitable number of Crowns.
Let me...
I want to add one more
Certainly.
point to that, or addition to that, if I may. Well, really two things. Firstly, what frequently happens is that a defense counsel will call a witness in an attempt to rebut a certain factual situation, hoping to neutralize a certain presumption. Let's say, for example, an obstruction at the door of the premises when police enter. Perhaps the witness will succeed in providing other evidence which neutralizes that presumption. But then the witness is open to cross-examination on all areas of the case, and frequently then answers are elicited from the witness concerning knowledge of what is going on in the premises, the nature of what is going on there. Perhaps the fact of a rake in a gaming house case can be proven through cross-examination that otherwise could not be proven had the defense witness not been called. Accordingly, I think defense counsel, when choosing witnesses to attempt to rebut areas where presumptions might apply, should use great care in doing so. And in the example that Lou gave concerning the obstruction at the door, perhaps you could call a cleaning lady or someone who could give some specific evidence about that one area, but who would know nothing about anything else that was going on in the premises. In other words, you must be sure when calling that witness that the witness can help you and won't at the same time crucify you in 3 or 4 other areas. And then as a final point relative to this whole matter, it should be obvious to you from what has been said by Lou and Peter here that these cases often change dramatically from minute to minute or from hour to hour, as the case may be, as the trial progresses. And a defense counsel may go into the courtroom thinking that his primary defense is along a certain line or lines, and then suddenly that area of the case collapses around him like a deck of cards, but something else totally unexpected opens up, and the Crown has failed inadvertently to prove some other area of the case. And accordingly, a defense counsel in this area has to be on his toes and able to spot a hole that develops sometimes very quickly during a case, be able to spot it not close the hole by calling defense evidence or by asking silly questions on cross-examination that settle the issue, and then raise the point to the trial judge. And it takes a great deal of dexterity on the part of defense counsel, and it takes a defense counsel who does not have tunnel vision and who can look at all areas of the case and pick things out as they progress.
Thank you. Let me ask you to turn your mind, Your Honor, to the whole issue of expert evidence when dealing with gaming houses. And have you had the opportunity to hear defense counsel call such evidence on whether a game falls within the definition of the code of being a game of mixed chance and skill or chance? And what is your impression of the nature of that evidence?
Yes, there are many areas where expert evidence is called to in the disorderly house cases. You gave one example, Marlys, with respect to testifying concerning the nature of a game. Other examples might be police officers called who have taken the 2 or 3 week course given by the RCMP and proclaim themselves to be experts in the field of gambling, and then they proceed, after being qualified, to tell the court about point spreads and the juice and various matters to which my friend made reference a few minutes ago. I have found that there is a great variation in ability among these expert witnesses. Some of them I have found to be very knowledgeable and can give excellent, explicit evidence concerning various matters. Others of these witnesses I have found to be terrible and very ill-informed concerning many areas of gambling. I do not classify myself as the world's greatest gambler or expert in the subject, but I have taken the time to read 2 or 3 books which are available to anyone in any bookstore on the subject, written by persons who are authorities in the field. And when I hear evidence being given to me that contradicts something that I have read the night before from another expert, I am somewhat dubious concerning the quality of the evidence being presented. Here, too, much depends on the skill of defense counsel. If the defense counsel is knowledgeable in gambling matters and is knowledgeable concerning the terms that are used, then he is able, often successfully, to cross-examine the expert Crown witness. However, if the defense lawyer is not knowledgeable in the field, then you have a case of the blind leading the blind, and the Crown expert's witness goes in unchallenged and unscathed, usually with disastrous results for the defense.
Lou, have you had any opportunity to use expert witnesses in this area, and how effective have they been?
Well, yes, I've had opportunity of using them. I remember one case in particular, the famous North York Bridge Club case, eventually went to the Supreme Court of Canada under the name Regina versus Ross et al. In that case, I had occasion to call Eric Murray, QC, as an expert on the game of bridge. That was the year that Eric reigned as the world champion, he and his partner having gained that title in Italy, and I thought his credentials were impeccable. The matter came on for trial in Toronto here before His Honor Judge Tupper Bigelow. Why, everybody know the joke? What happened was we called Mr. Murray, who gave his evidence in a very forthright and very expert manner, and indicated to His Honor that but for the deal of the cards, the balance was all skill. And His Honor leaned down and said, "Mr. Murray, are you telling me that there is no chance involved?" And Eric, quick as could be, said, "Your Honor, I've played with you. In your case, it's all chance." As a result, the conviction was registered, and the matter eventually went to the Supreme Court of Canada. Another instance of expert evidence is really for the defense to determine what it is they want an expert for. If somebody was playing gin rummy, there's not much point in calling an expert in gin rummy unless he's going to assist your defense. So if the evidence is that gin rummy is a game of chance, I've played with some people in this room and it is, there's not much point in calling him because you're not going to materially assist yourself. I think the essence then would be to attack the Crown's case. Now the Crown must prove its case, and its case is that this is a game of chance or mixed chance and skill. And ordinarily this is done by calling a police officer, which brings us into the realm of police officers as experts. There are those who are, notwithstanding the 3-week course from the RCMP. But by and large, it is my respectful opinion, they're not. They may give the verbiage and the veneer of expertise, but with rare exceptions, they don't have that degree of expertise. Again, in a totally different context, some year and a half ago, the ability of police officers to give expert evidence in impaired driving cases was attempted by yours truly in London, Ontario, again with lacquid mark of success. There was a conviction registered. It went to trial de novo appeal, again with marked lack of success, at which point I threw up my hands in disgust, and Eddie Greenspan was retained. He took it to the Court of Appeal and didn't succeed, but now the Supreme Court of Canada has given him leave on that very ground. So there may be some hope yet. Don't give up the ship, boys.
Let me ask you to, we'll ask His Honor for a moment to turn to the whole area of sentencing in this field. Is it true to say that in terms of keeping or permitting or taking bets or any of that general area of offenses, that primarily non-custodial terms are handed out and the court is looking for some fine that can reasonably be said to take away some percentage of the profits of the enterprise?
That is usually the principal matter under consideration by the court. However, if the enterprise were an extremely large one, for example, a betting enterprise that handled millions of dollars per month, or a bawdy house ring involving thousands or hundreds of persons, in such cases, a custodial term would have to be imposed as a deterrent to the offender, and I suppose also as a general deterrent to others in the community copying the offender's actions. It is difficult to discuss sentencing matters in the abstract. Every case is decided on its own merits. Every accused before the court is an individual with his own characteristics, background, and lifestyle, and every offense varies one from the other. And I don't want to be drawn into a discussion of providing information about sentencing in the abstract. I feel that I would prefer, if dealing with sentencing, to have a particular factual situation enunciated to me and then to proclaim what I would consider to be an appropriate range of sentencing based on that factual situation.
Okay. Peter, can you provide some comment as to what your policies or position have been with respect to custodial terms and fines when dealing with people who have this or convicted of this kind of offense?
It's not normally the practice of most crowns, particularly myself, to ask for custodial terms for this type of offense unless it's possibly the third or fourth conviction in a relatively short time, meaning say between 5 or 7 years, and that only as a specific deterrent. My own view is that there are a lot of other types of offenses which more clearly call for incarceration, and more attention should be paid to those. For that reason, I normally just submit that there should be a very large fine if it's a subsequent conviction, or a moderate fine for a first one. Unfortunately, this amounts merely, of course, to a license to continue and is not much of a specific deterrent, but I don't think on the case law we could ever hope to get a jail sentence on a first conviction for something like this, and I don't think a Crown would even be justified in asking for one.
Do you relate the amount of the fine you're requesting to the take of the house, for example?
We try to, one rule of thumb is about 10%.
That's what I was trying to get.
Isn't that similar to the juice?
Exactly, yeah.
And that's what it's primarily designed to take away then?
Yes, to some extent, that's part of the philosophy behind it.
I wonder, Marlys, if we shouldn't give attention to another aspect of the sentencing process, although it really isn't part of it. Of late, the internal revenue of this country has been very diligent. And I would advise, oh yes, they have. My advice to most counsel would be that be very careful when you're making submissions, and more particularly admissions as to sentence. Because as often as not, there will either be a little gnome in the back of the court taking notes diligently, or else when the expense account allows, a transcript will be ordered. The next thing you know, your client gets a reassessment from the tax department saying, "Dear sir, would you kindly remit forthwith $55,000, and they don't work at 10%, I assure you. So that is one consideration that today has to be given some very special attention.
If I may just stop you there, Lou. In that area, if a person's been charged and you know that the allegation will be that he's made a very substantial profit, and immediately upon being charged receives a little notice from the Department of National Revenue, what position would you take with respect to disclosure of your client's assets? Because I understand they're fairly willing to settle. And do you run the risk of jeopardizing their position in the criminal action?
You may well do. It's a very difficult decision. Anytime the Internal Revenue intervenes, the problems are multiplied, I don't know how many fold. I think the best advice that one can give their client is, firstly, to consider the tax aspect. And my position, by and large, has been to consult someone who is more au courant with the tax aspects of matters than I am, at least, if nothing else, to prepare a brief for me as to the pitfalls that may apply with respect to the particular client. I'm thinking of one situation that I have going at the moment. And I don't know that you can stave off the inevitable, but at least you are prepared to avoid the basic pitfalls that inevitably will come up.